Back on the record in the case of People versus Brandon Martin, RAF 1506112. Mr. Martin is present in counsel, the people present, all members of the jury and alternates are present. Yes.
Thank you, sir. You folks will remember several weeks ago when I was engaging in dialogue with you, and one of the first promises I extracted from you, and not everybody was able to make this promise, and they didn't make the cut, if you will. And one of those first promises I extracted from you was that you would approach this case and you would wait to see whether you're convinced beyond a reasonable doubt that Brandon Martin committed these crimes. You remember, everybody gave me nods on that. You said, yes, as I sit here right now, I presume he is not guilty. And then unless it's proven to me beyond a reasonable doubt, I'm going to vote not guilty. Well, folks, now is the time to make good on that promise. Now is the time to separate the emotion and the vitriol and the hyperbole that the district attorney engaged in his closing remarks, and to focus on what you're supposed to focus on. And that is the evidence. Statements from the witness stand and the exhibits. That's the focus. And you're supposed to do that dispassionately, without any emotion, and without any bias. Now, when you eventually get to deliberate, and again, it's not as if you have not been working. I've kept my eye on you folks. You're listening, you're taking notes. I can tell you're processing what's going on. But you wait. The real work is going to begin when we're done talking to you and you go to the jury room. And the 12 of you get together and you attempt to make a consensus. You attempt to get a unanimous decision. And when you do, you're going to have to answer at least one and possibly two questions. The first question you have to answer is, am I convinced beyond a reasonable doubt that Brandon Martin committed these crimes? If you do answer that question in the affirmative, then you get to the second question, and that is, am I convinced beyond a reasonable doubt that if Brandon did commit these crimes, he committed them with premeditation and deliberation? So that's the one question you're going to have to answer. You might get to number two. We'll talk about that as we go along. Question number one, am I convinced beyond a reasonable doubt that Brandon Martin committed these acts? Number one, at the outset, there is no direct evidence that Brandon Martin committed these crimes. There are no witnesses. There is no statement from him saying he did it. Therefore, you must rely on the circumstantial evidence. And in order to do that, you must evaluate the circumstances surrounding these events. So let's do that. Number one, when you look at the circumstances surrounding these events, the first thing that jumps out to you is there is no physical evidence linking Brandon Martin to these crimes. Specifically, the murder weapon, the bat. There is nothing that puts that bat in Brandon Martin's hands on that day in September 2015. There are no fingerprints. There is no DNA. There is nothing linking Brandon Martin to that bat on that day. Second, when Brandon was arrested, his clothing, you can imagine it was processed. And what are they looking for? What would you look for? You don't have to be a forensic scientist. What would you look for after Brandon was arrested? Blood, right? You look to see, is there blood? Because we've all seen these crime scenes. We're all familiar with head injuries. What do head injuries do? They bleed. And if there's any question about that, the photos of the crime scenes answer that question. There's a significant amount of blood in that living room, in that kitchen area, and in that garage. Yet miraculously, none of it is on the clothing of Brandon Martin. Where was Brandon Martin for the 15, 18 hours after this act? He was basically living in that truck. He told Detective Gottfried when he was interviewed that he spent the night in the truck over by where he had tossed the wallet. You know, they went over that truck with a fine-tooth comb. In fact, you saw some photos of the truck. I think we had the Carl's Jr. burrito wrapper was in there, among other things. No blood found in the truck. No physical evidence on his clothing, no physical evidence in the truck, where he spent basically all of his time. There were no footprints, no shoe prints at the scene connecting Brandon Martin to walking through that scene, committing those acts. Look at Brandon Martin's actions after he left that location and ask yourself, are those the actions of someone who committed these acts? First thing he does when he leaves, he takes the dog. The dog was with him when he was in that truck, when the truck got pit stop. Secondly, he takes the truck, but where does he go? He doesn't go anywhere. You saw that map, Exhibit 241. You saw all those various dots. He doesn't get more than a mile away from his house. He spent the night mere blocks away from the house. He was arrested less than a mile from the house. He doesn't go anywhere. Is that the actions of somebody with a guilty conscience who commits these acts and says, I got to get out of here? Yeah, he gets the transportation. Easy enough to get on the 15 head north, the 91 head east or west. He doesn't go anywhere. He never leaves that little triangle between the 15 and the 91. And there's no motive. There's absolutely no reason for Brandon Martin to have committed these crimes. Let's talk about the law on motive. And when I talk about the law, I'm going to read the law to you because you will hear us debate the facts and you will hear us debate how the law applies to the facts, but you will never hear us debate what the law is. That's why I want to read it to you so there's no question. The people are not required to prove that the defendant had a motive to commit any of the crimes charged. In reaching your verdict, you may, however, consider whether the defendant had a motive. Having a motive may be a factor tending to show that the defendant is guilty. Not having a motive may be a factor tending to show the defendant is not guilty. In his opening remarks, and just a few minutes ago, Michael Kurse, the prosecutor, painted Brandon Martin as an abandoned soul. Someone who was rejected by his family. Folks, the evidence does not show that. In fact, the evidence shows just the opposite. What did Michael Anderson say to you? He was frustrated with Brandon. He was mad at Brandon. He wanted Brandon arrested. But once Brandon was at the 72-hour hold, what was he doing in conjunction with his mother? They were working to find places to send him. All right, the family's been told, you've got 3 days to figure this out, and that's what they were trying to do. They didn't get the 3 days, but that's what they thought they had. So no, nobody rejected Brandon. Nobody abandoned Brandon. His family is all he has. They weren't just going to toss him out on the street. Mr. Kurse makes much of the fact that Brandon Martin defied authority. When by being told by ETS he can't go home, he defied authority. What is this young man supposed to do? Is he supposed to join the homeless population under the bridge? Is he supposed to grab a shopping cart, put all his belongings in, and sleep in a bush at night? Because what other options did he have other than defy authority by going home? Folks, he had no motive to commit this crime because that was his entire life. The only thing he had was his family. Why would he destroy the only thing in his life that is stable? Why? There's absolutely no reason for that. When asked by Detective Gottfried what he likes, one of his answers was he likes not being alone. Now, I can hear you, or I hear you thinking, I can see the wheels turning and saying, okay, Jensen, if Brandon Martin didn't do this, who did? I don't know. And more importantly, for the purposes of your job, you don't care. You will hear a lot of people say, oh, a trial is a search for the truth. No, it is not. We're not here to determine what happened. A trial is an accusation brought by the prosecutor. And then the prosecutor puts on evidence in order to establish that accusation, to convince you beyond a reasonable doubt. And it's your job to determine whether the prosecutor has in fact established that accusation beyond a reasonable doubt. It is not your job to determine the truth. It is not your job to find out what happened. So that question of, well, if he didn't do it, who did? That's irrelevant. The question is, has it been proven to you beyond a reasonable doubt that Brandon Martin committed the crime? That's the only question. Don't get caught up in that. And in this instance, the people have not met their burden. There is no direct evidence that Brandon Martin committed this crime. There is a lack of any physical evidence tying Brandon Martin to this event. Brandon Martin's actions after leaving the scene of this incident belie someone who committed these crimes. And most importantly, there's absolutely no motive for Brandon Martin to have committed these crimes. Any one of these four areas should raise the specter of reasonable doubt in your mind when you're evaluating this case. But when you put all four together, when you add up all four, they create a significant amount of reasonable doubt. Let me take a break. Let's talk about the four remaining counts. Two are real easy. The 2800.2, the evading the officers. Everybody remembers Brandon's statement when he was at the jail? They asked him, why are you here? He goes, I ran from the police. Okay? He, in essence, has pled guilty to evading the officer. That one's done. Secondly, the taking of the truck, the 10851. Again, remember when Brandon spoke to the police? What'd you do? I took the guy's keys and I took his truck. Okay, boom. In essence, he pled guilty to that. That one's done. Let's look at the other two. Penal Code Section 69, which is basically, resisting an officer when he's in his duties, and the Penal Code Section 600, the beating of the police dog. And I group them together because they rise and fall on the same set of facts in the same law. It's all part and parcel with that same event in the backyard there on Derby. You remember the facts. You've got Brandon, who's taken a fall, who jumped from a second-story window, and we all know that it wasn't 8 feet up there. It was probably more like 15 or 20. Lands on the concrete. Good chance he's unconscious. What did Officer Bennett say? He was on his side. I didn't even know if he was conscious. I'm sorry, Officer Bajin said that. Officer Bennett said, I saw him lying prone on his back, looking up, and yes, I saw his eyes were open. Either way, the man has just jumped out of that window, and what did both officers agree on? He didn't move, did not acknowledge their presence, didn't even look to see where the voice was coming from. There wasn't a twitch, there was nothing. I think the phrase Officer Bennett used yesterday was he was motionless. One command, show us your hands, he does not comply, deploy the dog. Whether he's just laying there, conscious or unconscious, he is awakened by the dog in his crotch. What was the word that Brandon used when he was speaking to Detective Godfrey? The dog bit my private parts. Folks, that'll wake you up. And what is the natural human reaction when you do that? Get that pain away. Very painful area in the male anatomy. What's your reaction? Get it all. And that's what we do. We saw Officer Bajin demonstrate, remember what he was doing last week? This, right? There's the dog, and there's Brandon trying to get it off of him. Now, why is this important? Well, you have to ask yourself, was this use of force reasonable given the situation? There is no question these officers have every right in the world to arrest Brandon Martin. That's not the issue. The issue is, did they go about it in a reasonable way? Yes, they're allowed to use force to effect that arrest. Was it reasonable? Ultimately, that's for you folks to decide. Here's the law on that. If a peace officer uses unreasonable or excessive force while arresting or detaining a person, that person may lawfully use reasonable force to defend himself or herself. It just makes common sense. That if a peace officer, when effecting arrest, goes too far, the person being arrested doesn't have to sit there and take it. They can resist if their resistance is reasonable. A person being arrested uses reasonable force when he, one, uses that degree of force that he actually believes is reasonably necessary to protect himself from the officer's use of unreasonable or excessive force, and two, he uses no more force than a reasonable person in the same situation would believe is necessary for his or her protection. Ladies and gentlemen, I submit to you that Brandon Martin lying there unconscious, and he's brought back to consciousness by a dog latching onto his groin, that he's acting reasonably in attempting to get that dog off of him. And that dog was locked on the entire time. You heard Officer Bennett testify that it was not until the hands were cuffed behind the back that he gave the motion to have the dog unlock his chain. That's why he's not guilty of those two crimes. Now, I'll be honest with you, I think there's a big part of me that would just like to sit down and say, I'm done. I've argued this case. I think I've demonstrated to you that there's not sufficient evidence to convict beyond a reasonable doubt. But I'm aware that some of you may take issue with the points I have set forth. I'm aware that the possibility of one or more of you may be convinced beyond a reasonable doubt that Brandon Martin committed these acts. And I would be remiss if I did not address those people and did not address that issue. So that's what I'm going to do now. Because the second question then you must confront is, am I convinced beyond a reasonable doubt that Brandon Martin had a mindset of premeditation and deliberation when he committed these acts? The crime of murder requires two things: intent to kill and malice aforethought. The crime of first-degree murder requires three things: intent to kill, malice aforethought, and premeditation and deliberation. If you believe Brandon Martin committed these acts, there's intent to kill, there's malice aforethought. The issue you must confront is, am I convinced beyond a reasonable doubt that he did these acts with premeditation and deliberation? The law says a decision to kill made rashly, impulsively, or without careful consideration is not deliberate and premeditated. On the other hand, a cold, calculated decision to kill can be reached quickly. Here's the key phrase. The test is the extent of the reflection, not the length of time. The extent of the reflection. To ask yourself, over the last 5 days, from what you've heard, from what you've seen, was Brandon Martin capable of engaging in reflection of the consequences of his act? Michael Anderson told you that the Brandon Martin he knew kind of disappeared in 2015. That when he tried to talk to him in 2015, he realized it'd be a waste of time because something in his eyes. Officer Sandoval told you that with 7 years of experience on the force, he'd encountered situations like this before, and in his expert opinion, he felt the best thing for Brandon Martin would be to get a psychological evaluation. In other words, let's take a 72-hour time out. It didn't last 72 hours, and here we are. That was what Officer Sandoval felt. Ask yourself, are Brandon's actions, and we talked about these actions earlier, but now examine his actions in light of whether you feel that he was of a mind that he could reflect on the consequences of his act. Was he capable of reflection, folks? When he leaves, he takes the dog. They asked him, why did you take the dog? He said, because I don't want to be alone. When he leaves, he doesn't go anywhere. He doesn't get further than a mile from his house. And when he's confronted by the police officer, when he sees those lights and hears that siren, he pulls over. Got his hands hanging out the door. Remember that? For a good minute. And then something happens, and he drives away. And as Officer Begin says, drives away slowly. As Officer Begin characterized it in his report, this was a low-speed chase. The guy never got above 35 miles an hour. I think the one pit maneuver he was going 30, the other one he was going 29. It's almost as if he is lost. And I don't mean lost geographically, I mean lost mentally. It's almost as if he is confused. It's almost as if he's torn as to, well, what do I do? I'll pull over, and oh, maybe I'll go, but I'm not going to go fast. And then, most importantly on this issue, do me a favor. Listen to Brandon's statement again. And when you listen to it, ask yourself, am I listening to the reasoning and the logic and the inflection of a 22-year-old man? Am I listening to an 8, 10-year-old child? Detective Godfrey asks, who did the keys belong to? Remember he said? Dead people. Who says that? She asks, what do you enjoy? He said, I enjoy every aspect of life. Like what? Remember what he said? Eating dinner. Who says that? When asked, is there anything else? He said, I enjoy not being alone. Ladies and gentlemen, are these the statements of someone capable of a cold, calculated decision? When confronted with why he was in custody, Brandon said, well, I ran from the police. Yeah, but you're here for murder. What? Murder? Again, listen to the words. Listen to the inflection in his voice. He was as surprised as anybody to hear that. So again, review what Michael Anderson and Officer Sandoval observed. Study the actions of Brandon at the event. Listen to his statement to the police. And when you evaluate all this, you'll find you're not convinced beyond a reasonable doubt that Brandon Martin committed this act with premeditation and deliberation. Now, as the judge stated, when I sit down, the prosecution will once again get the chance to address you. It is called rebuttal. They, in other words, get the last word in. The reason being they have the burden of proof. So when you listen to what the prosecutor has to say, and more importantly, when you get into that jury room and deliberate, I'd like you to conjure up this picture. And the picture is as follows. This trial, any jury trial, is you are going through a forest, and it is the district attorney's job to get you from one edge of the forest to the other. And as the district attorney is leading you through the forest, there is a gorge. It is wide. It is deep. The only way you can get across is to build a bridge. Anybody who's ever built anything, or anybody who's ever cooked anything, anybody who's ever made anything, you need two things. You need plans, and you need materials. You have been given the plans, those jury instructions, that law that the judge read to you, those are the plans. The materials to build this bridge are supplied by the district attorney, by the evidence. And the first bridge you have to cross in this case is, am I convinced beyond a reasonable doubt that Brandon Martin committed these crimes? So when you begin to assemble your materials to build that bridge, you're going to find that they're lacking. You're going to find that there's a lack of any direct evidence linking him to this crime. There's a lack of any physical evidence. linking him to this crime. Brandon's actions after leaving home are not the actions of somebody who committed these acts. And there is no motive. So when you begin to build that bridge, you're going to find that it won't be long enough, and it won't be strong enough, and you can't get to the other side. But again, I have to bear in mind, some of you might say, no, I can get to the other side. And if that's the case, then guess what? Your journey is not over. Because if you are to convict him of first-degree murder, you must build a second bridge. And again, with the first bridge, you've got the plans, the law. Do they have the facts? Okay. When you're building that second bridge, ask yourself, look at the observations of Michael Anderson and Officer Sandoval. Look at the actions of Brandon Martin after the event. Listen to his statement. You're going to find, once again, you just don't have what it takes to get to the other side, to be convinced beyond a reasonable doubt of premeditation and deliberation. Listen. When we chose you as jurors, I knew, you didn't know, but I knew we would be at this juncture at some point. And I am confident that the 12 of you will discharge your duties with much, much work and much thought. And I'm confident that you're going to return the proper verdicts. Thank you all very much.
Thank you, Mr. Jensen. Mr. Beacon, we have 15 minutes before noon. Do you want to come back at 1:30 or?
You have additional instructions to read? All right. I think 1:30 would be better.
All right. So, ladies and gentlemen, go ahead and break. We obviously have one rebuttal argument, and then I have some additional law to read to you. And so we'll be coming back at 1:30. I do have a question, though, that I may as well ask of you now. There's something else going on today other than our trial, as you're all aware. And my question would be just for our deliberating jurors, because our alternates are excused until verdict. There's some issue, of course. And so my question is this, to the extent any of our 12 deliberating jurors have not yet voted and do want to go to the polling stations, then I'll be more than happy to accommodate you. And after the closing arguments are done, we'll be excused. Otherwise, then obviously we would have to deliberate in the afternoon. So let me just ask in the jury box, is there anybody that needs this afternoon to vote? Obviously, allow you. How about outside the jury box or others? All right, so then we'll have you deliberate this afternoon. I'll talk a little bit more about it when we get there, but just to let you know, our schedule is going to be today, same as it would be any day. That is, it would be any later than 4 o'clock. So if no verdict is reached by then, obviously you can come back tomorrow. And the reason that we need to do that is we have to get all the parties together and have that taken care of by 4 o'clock. If there's no verdict today, then you'll come back tomorrow morning. Talk a little bit more about the schedule. Remind all of you not to discuss facts of this case amongst yourselves or with anyone unrelated to the trial.